Minnesotans have the right to obtain a list from the controller of the specific third parties to whom the consumer's personal data has been disclosed, or if the controller doesn't maintain that list specific to consumers, consumers can get a list of all the third parties to whom personal data is sold. We see similar requirements in laws in Oregon, Delaware, and Maryland, although there's a bit of variance between them. What's more interesting to me is that Minnesota has added a new right that we haven't seen prior to this point, at least in the state comprehensive privacy laws. So under this law, consumers have a right to contest adverse profiling decisions, meaning that if your personal data is profiled in furtherance of a decision that produces legal effects, the consumer has the right to question the results of that profiling, to be informed of the reason that the profiling resulted in that decision, and, if possible, what actions the consumer might have taken to secure a different decision, and the actions that they might take in the future to secure a different decision. The consumer also has the right to review the personal data that was used in the profiling, and if the decision was based upon inaccurate personal data, the consumer has the right to have that data corrected and the profiling decision reevaluated based on the corrected data. And when I say profiling in furtherance of decisions that produce legal or similarly significant effects, that's a defined list. There's a specific set of things that that refers to. So go to the definitions under the law to see what decisions are in scope of this right. And I will flag, Minnesota was the first state to have this right, but earlier this year, I believe Connecticut actually went back and amended their law to add a narrower version of this right to contest profiling decisions